Okay. All right. So I guess it's another Q&A this evening. We're going to go over defects in paperwork, and we're also going to probably try and talk about court seals and what is and what isn't requisite for those things. So tonight, I've got a friend with me. Would you like to introduce yourself or say hello?
Hi, I'm using the moniker Mama Bear.
Right.
And we made one another's
Okay, so we haven't even
acquaintance.
been on a full minute. StreamYard's already given me lots of trouble. That's awesome. There we go. Cool. Gage, as always, your platform is horrible, and I'm going to stop using you someday and start using Restream.io. And this is a shameless plug. Restream.io is far superior to StreamYard in every way, shape, and form. And the only reason that I use this platform is to be able to make fun of it. So cheers to that. And how are we doing this evening?
How are you doing?
Oh man, I couldn't be better. I've had a little bit of personal garbage pop its way up into the frame like it always tends to. Other than that, everything's been pretty good, pretty good. I can't complain. So I guess we are going to get into some stuff tonight involving a 62 statute at large, page 915. We'll get into 28 U.S. Code, 18 U.S. Code. We'll get into the Code of Federal Regulation 28 and 32, and it looks like 36 and 19 as well. We're going to talk about judicial canon, and we'll probably talk about some other stuff. So you want to go ahead and get started, or you want to fill us in on kind of your situation here and what brought you to this channel in the first place?
Yeah, you and I made one another's acquaintance on last week's Save Our Children Truth Commission powwow, where we support one another and try to get our paperwork straight. My husband calls it a support group, but if you don't give up, there's a greater likelihood of prevailing. So
it is definitely a support group, but I mean, anybody thinking that they can do this without help is going to find that they were mistaken, and probably pretty promptly. This is something that they don't teach us. They don't teach us this kind of stuff in school, and it's because of this that it feels like there's two different legal systems. And really, to be honest, there is. You know what I'm saying? There is two different financial systems as well. Like there's a different banking market and all that for people that operate the private side of commerce. That's a transition that all of us probably should make. They say when you're a child, if you have a heart, you're a liberal, but as an adult, if you have a brain, you're a conservative. But I think that just moving off into the private is good enough, because both of those things, to me, anyways, are just two slightly different looking puppets on opposing sides of the same tiny hat,
So after the Save Our Children powwow, availed myself of your generous offer to speak outside of that forum, and we had some ideas. I haven't gone into the fullness with you of what all we've tried already, but in 2015, our youngest, who was then 4 years old, I sent him to public school with a minuscule injury on his bridge of his nose. It was accidentally incurred. It was treated appropriately. So we, in our naivete, thought that the system would work. It did not. The system should have worked like you see on TV, where you go in, you tell the truth, the whole truth, and nothing but the truth, and they say, oh, wow, why was CPS contacted? This is absurd. And everybody goes home. Instead, they were kidnapped right out the back door at the quote, forensic interview. We know that the kids were brainwashed at that encounter, and we haven't had a moment of parenting time since. We had to endure a forced guardianship, a coerced guardianship, coerced mediation. That's a farce, that term. There was no mediation. There was what the guardian wanted, and we had no choice but to acquiesce on every and all point. And my efforts since the quote judge, since learned that he's nothing but an administrator, slammed his gavel down saying, y'all get out of the kids' lives. I'm giving the guardian the children on a permanent, as a matter of permanency. We've got your kids. Everybody get out of my face. Since then, I have done a few things. I have, because this occurred in a remote state, I've not been able to physically walk in and hand my motions in. But given the fact that there are no attorneys who are willing to oppose this beast, I've had to generate my own paperwork. I used a book called Sui Juris as my guide, and I proceeded as follows. I generated camera. I generated a motion to vacate based on Rule 60B. I studied a little bit of common law and looked at abatements. I sent in a quo warranto. Hey, by what authority are you pulling this nonsense? Motion to dismiss for lack of subject matter jurisdiction. I sent in motions for an intervener. I have a very large family of very incentivized natural blood relatives. They would rather the children be with us. And I sent in a petition to motion for virtual visits. Not a one of these motions has been acknowledged. When I started taking classes with retired bar attorneys, I was told, hey, have you sent in a motion to hear your motions? At which point I realized it's nothing but a stinking game to these people. I have to send in a motion for them to consider the motions that I've already motioned. It's a game.
Right.
And you've given me some insights since having made your acquaintance about it's a language game, it's a securities trust fraud game, it's a power game. So that's where we stand, and now we're going to discuss. Yeah, they won't give us our records.
Right.
Whenever I've requested the records, their response was, no, you're the accused. As such, you're not entitled to your records. That's both from CPS as well as the quote court.
Anything that's going to be used against you has to be presented to you in an initial disclosure. It's not even a discovery issue. This is a threshold dispositive issue. It has to be settled like jurisdiction before anything else can fucking happen. You know what I mean? So that right there's a violation of your rights of due process. I'd make a criminal complaint and send it into the Navy JAG for your district and send it into your federal district's assistant deputy prosecutor. This is how you handle that. Then the marshals go and arrest that judge. Broad day, right in the middle of their business day, you know?
Okay. I'm going to rely on this recording.
Oh, you won't really need to take any of this down or anything like that. This will be available for replay. I'll send you a link after it's over.
Marvelous. Thank you.
So what are we looking at here?
They're hiding. It's a RICO crime. What are we looking at? This is the ultimate Last Supper. It's Almighty.
Sure. Okay.
Heavenly Father.
Right. Yeah, but you were saying about the RICO?
Okay, so RICO crimes. Why is it a RICO crime? It's a RICO crime because the judge couldn't get away with it unless he had somebody pretending to be the eyewitness, and the furtherance of the crime couldn't proceed unless the psychologist were willing to breach his oath to first do no harm and to just write down oh, these parents, they're a train wreck, narcissistic, borderline personality disorder. I'm sure if we were to audit the therapists, the rapists, the therapists, records, we'd find that there was a common thread. They overused that
Right.
designation.
Yeah, no, there's a definite etymological thing right there. Not to cut you off, but yeah, it shouldn't take much for somebody to catch those kind of things, but they never do. You know what I mean? They never do. Like we live around people that don't have any idea of what's going on around them. It's insane.
Yeah,
Go
that's
ahead.
how
Sorry.
terrorists got the name. The rapist. That's what they do. They are raping and pillaging. But you were saying it is a rape and a pillage. It's piracy. All the
Absolutely.
admiral. Yeah. Yeah. Okay. So you were going to. Oh yeah. If I could get a single document, I'd be able to verify whether or not this matter of the seal being valid or not valid. All I have is the quote final order from 2020, and it appears to be a stamp. And you were saying that the best place to go for that was our friend, internally displaced court seals. What was her name? FIBB or something like that.
Now, what's that?
What was the name of our friend that you said, go check out her materials?
Oh, Jackie Fig. Yeah, Jackie Fig. Absolutely.
Jackie Fig. And I'm going to, take to heart all she has to share. Another gentleman who's been helping us has also shared all that information too. It can't be a stamped signature, but oftentimes these clerks are just stamping it, which invalidates the proceedings. And the other matter was, what was it? Constitutional or 18 USC 241, 242. Are you awake?
Yeah. So this would be deprivation of rights under color of law. Yes, certainly.
Yeah. Okay. 241, 242. And one of them was conspiracy, right?
Yep.
Yeah.
Yep.
I need to.
One's conspiracy. Yeah. Sorry, I'm trying to look this up real quick. Go ahead.
Okay.
Hello?
Our friend Tonaway has.
No, you're fine. You can keep talking.
Okay.
I can't do two things at once. You're fine.
Our friend Tonaway has served 2/3 of the state. We're still trying to figure out a way to get him to serve Tennessee. 18 USC 241, 242. I guess he's serving them to the attorney generals in each state, telling them, look, y'all are.
Yeah, you'll have to. You'll have to.
Oh, that's the other thing.
When you do a color of law, you're supposed to send it to the DOJ, to the attorney general. Yeah.
Okay. When
go ahead.
When he laid out his November 2020, I guess it's fiat decree, get out of the kids' lives. And I don't know if I should be using the word kids or offspring, or I just use my family is Hawaiian, so we use the word keiki.
Yeah, you can. I guess the nice. The regular nomenclature is fine. You know what I mean? Like however you want to say it. I think everybody that's made it far enough to even care to try and watch one of these understands that there's a lot going on with the words. And see there, I just said understand. Some of these people get anal about that. Oh, we don't understand. We overstand. We understand it. And while I get that all that is real and it's really happening, I don't care. I don't have to play that, which you know what I mean? Because I'm not a person. That's for persons. Oh, that's for persons. My person is this carbon vessel that I'm walking around in, but that's not me. Just like my name isn't me. You know what I mean?
Mm-hmm. Okay. I'll use any term. I might slip and use kid, children, offspring, keiki, one of the above. But in that,
whatever works for you. Absolutely.
his final legislating from the bench decree, whatever, that's the only instance I have, example I have to reference, because I can't get the materials themselves, the fullness of the record. Okay. I'm ready for you to.
Okay. Well, I was just getting some stuff lined out here. 18 U.S. Code 505. It's going to be seals of the court. Let's see. Get on the screen real quick. Sorry, stand by.
Yes, of course.
So it's 18 U.S. Code 505 covers the use of forged and counterfeit seals and signatures by judges, court officers, and courts. So this would include a judge's signature. This would include a rubber stamp or a lithograph, forging or counterfeiting a court seal, which I would assume also probably work for 90% of the court cases out there, as they don't follow regulation, and they just don't. It's it's crazy how they're getting away with this stuff. It's really insane. The amount of stuff is getting past us that we're not seeing. So
because we're in the dark. We have no expectation.
And this is really where the madness is. You know what I mean? It says those who commit these acts can be fined, imprisoned for up to 5 years, or both. This applies to courts in their territories in the United States. You might mute out when you're not talking. That way it doesn't give feedback. This is all under Title 18 of the USC, which is the main criminal code for the federal government. It also covers the federal crimes and criminal procedure, and it also covers state governments. So state actors acting in their official capacity from the state would also be in that list of people, that this covers, just like a 42/1983 would cover federal, crimes, but it's also state crimes. And it's I guess it is difficult to think of these things as crimes, all things considered, but it is what it is. Let's see. The next one I wanted to cover was going to be the Code of Federal Regulations, Part 803. So this is going to be the authority comes from 5 USC 301, publication L, page 105 through 133. So it's 111 statute at large, 251, 712, and the DC code is 24-11 or 133. Of course, this doesn't necessarily apply to us. So let's see. Got to get back here. I can see what I'm doing. I am going to just take this and let the thing read it to us because I like it.
Description. The Agency Seal of the Court Services and Offenders Supervision Agency for the District of Columbia, CSOSA or agency, is described as follows: General George Washington's coat of arms in red and white, bounded by an outline of the District of Columbia and superimposed upon a blue field together with the dome of the United States Capitol building in gold. Encircled by a banner with the words "Community, Accountability, and Justice," and gold laurel branches, with gold edges bearing the inscription, Court Services and Offender Supervision Agency, above 3 stars at either side of the words, District of Columbia, in smaller letters in the base. Letters and stars in gold. A reproduction of the agency seal in black and white appears as follows. Web links.
Okay, and so what it essentially is showing right here is going to be the way that these seals work or are supposed to look. I don't know if that's going to Yeah, actually, it wasn't too bad. We got
Yeah,
another one right here. So this would be for the DC seal for the District of Columbia, and all of these things will be approved by the Supreme Court for this district. You know what I'm saying? So, like in Kansas, it's going to be the Supreme Court of Kansas that's going to say this is what's required of the courts, which are not really courts. These are administrative in nature, and they're executive in nature. These aren't even judicial branch members. So, and we know this because they're put into the office, or they're put on the bench into office through a process of merit selection, which means they're not voted for. A bunch of attorneys and local business owners will pick who's going to be your next family court judge, and then the court clerk picks which one of those you get. You know, so if there's a conflict of interest, or there's a conflict of interest concerning relationships between the judge and the adverse counsel, as in my case for custody, they should be disclosed, and the judge should recuse themselves, but they won't. And so you have to go after them for this stuff, just like we were talking about the criminal complaints. It's something that you can talk all day about how you're going to sue them, and they don't care. 90% of everybody in there is telling them they're going to sue them, and 90% of all those people aren't even going to try, and 90% of the ones that do are going to fail. You know what I mean? Because 100% of them ain't going to be able to get representation, and that's because it's disinteresting for an attorney to help you in this case, because if they help us topple this system, then I mean, what do you think is going to happen to them? They know what's going to happen to them, and I know what's going to happen to them. It's not even a question. These guys are going to be fucking tap dancing without a floor, and oh boy, I'll rue the day, man. You know, my heart goes out to these poor shyster, petty, document salesmen that really don't know anything about law and lean on their underpaid paralegals so they can pay off the debt that they went into, that hundreds of thousands of dollars right out of high school. These people are sociopaths, and they're narcissists by trade. So, which makes them easy. They're low hanging fruit. It seems like they're not. And it seems like the government is huge and it's a big machine. How would one person ever fight it? It's fucking compartmentalized. And I have terrorized certain groups within my state. Agencies, oversight committees. The ombudsman for the CFPB won't call me back because he knows I'm about to sue the shit out of him. Same thing with the FTC. They've got some problems happening here. And mainly personified in this case by yours truly. And that's all you need to do. There's a website called Government Manuals, and it's got every government manual that you could ever want to read. And why would you want to read the government manuals, Mike, you might ask? And that's because if you have the court clerk's book, then you're going to know way more than the court clerk does about what she can and can't do, because that chick's not going to read it. I promise you. And therein lies the challenge, man. It's a side quest. Like, do you want this or do you not want this? So go get it. You got 2 hands, 2 eyes, open that book and get going. Click on that link and download the thing and get going. And then once you know what they're supposed to do and they don't do it, this takes them out from under the umbrella of surety. They're no longer indemnified, and someone can't pay for their attorney and can't pay for their damages and stuff to be awarded. So this means that the man or the woman is now showing up in court, and not the person who acts as, because the person who acts as has insurance. And so this also dispels the notion of immunity. There is no immunity. If they were immune, they would not have insurance. They have insurance. So tell me what that's all about. They don't have immunity. What do we got here? What document are we looking at? Ma'am, you're muted out. I'm
Thank you.
Yep. Oh.
It's just, I turned it over to you, having lost my train of thought. Here's picking up that train. Another means by which I've tried to tackle this is by supporting people who are in Washington, giving them this document. Hey, hand deliver this to any senator who will read it, any House of Representative, any rep who might read it. And it basically says there's a lot of talk about these migrant children, how the Biden administration lost track of hundreds of thousands of them, yet natural families from here in the United States are being trafficked. And, RICO crimes are occurring all day, every day. I have the proof. I know of one grandmother who had the QSIP numbers researched, and they've already siphoned, as of last accounting, $440 million. That was a year ago.
Jeez Louise.
Yeah. That's for 4 kids, 1 year. That's how much they got as a result of these shenanigans. And I've been writing quarterly. At first, I was just writing my reps. I maintain an address in Tennessee, so I could, my rep, Tennessee reps, Marsha Blackburn, for example. Nobody so much as writes back. They just give you this form letter that says, "Oh, thank you for reaching out." And the same thing has happened when I opened it up to a greater audience. And I only chose 2/3, but I've given it into the hands of all the reps, the senators, 2/3, Governor Bill Lee, POTUS, the Attorney General Skermetti, and the Department of Justice Federal. Nobody so much as writes back. I've been writing quarterly, 4 times a year. Nobody has responded.
Right. Well, I mean, they don't respond, and this is kind of the way that it goes. They try to obfuscate and do everything they can to keep us from getting any kind of traction. Because if they sit there and like these oversight committees are all run by people that used to work at these agencies. So like at the bar, for example, if you're trying to file a bar grievance against an attorney, know that it's going to be a waste of your time, except it's not. Like the attorney's not going to get punished. They're not even going to get reviewed for this or investigated or anything like that. What will happen though, is they'll take your complaint and they'll read it and they'll laugh at you and they'll throw it away. And then they'll call that attorney up and say, "Hey man, you got to let your insurance know this guy's got a potential claim against you." And that's going to make their indemnities go up, man. I'm talking like to the tune of maybe $1,200 a month is as much as I've heard, but it's hard to investigate or find out any kind of viable, repeatable, worthy sources for this kind of stuff, because attorneys don't talk about this. But like, I know that it works. I know for a fact that it works, because when I brought it up to the head of the state bar here, when he was helping traffic my kids with his Nazi ass, I mean, literal grandson of fucking Herman Goering ass, he gulped so hard that his fucking Adam's apple went up into his nose. You know what I mean? So it's it's clear to me that this is how you hit them. And the attorney is the chink in the armor. That's the weak link. You can get through, whether it's criminal or civil, whether you're in an Article 1 or Article 3 court. If you can get past that attorney and get his defenses down, then it's over. You don't have to play rope-a-dope. You don't have to do anything. You'll destroy this guy just based on procedure. And that's kind of what we wanted to go over tonight, is the defects in the paperwork. Right. If there's no declaratory statement, for instance, if there's no jurat swearing to the veracity of the statements made in that document, then that's not a lawful document. It's not a legal document. It's not a valid document. So therefore it would be void on its face, in ab initio nunc pro tunc, which means from the beginning, like from its inception, from its creation, from now until then.
What did you say? Ab initio, what?
Ab initio, AB, and then that's 2 words, and then INITO. Ab initio means from its conception, from its birth.
That
from
one
its,
I'm familiar with. What was the other one?
Nunc pro tunc. Nunc pro tunc, NUNC, Nunc pro tunc means from then till now, or from now till then. Sorry.
Right. So I should.
And this is how you kind of have to. Yeah. Pardon?
I should compose vacate void orders for defects in the paperwork.
Sure.
Okay, next. Okay, I'm
Let's
gonna
see what
try.
kind of stuff we've got. I've got the federal forms and pleadings from O'Connor's, and it's really handy. If you're a member of the Telegram group, you can grab all these things. I don't charge for any of my documents because money's not real, and you don't need it to live or function or move around in commerce. So,
Bleak.
yes, ma'am, that is I. Let's see what we got here. As far as quashing, if this is a pleading, you would want to strike the complaint. You know what I mean? So if you're at that step, like at that stage in the game, then you want to strike the pleading or strike the petition. If you're in the discovery process and prior to a pretrial conference, then the things that you're coming up with that you want to be suppressed, it's a motion to suppress. Because they're going to turn this in as evidence. And once it's in there, if it's a trial by jury or a jury trial, then this is all stuff that the jury's made aware of. You know what I mean?
We were denied jury. Nope. No matter how we tried to introduce exculpatory or have witnesses in our favor or present the video we had of our son saying, I am sorry. Whatever I said leading to all this, when can I come home? That was what was quashed.
Yeah,
we still have that video from him when he was 4 years old. The person who was supposed to be supervising the visits is out on the front porch, and he comes to us and says, I'm sorry. And he wants to come home. And I think his exact words were, what I told the cops led to all this. I'm sorry.
Yeah, I mean, that's heartbreaking. It really is. And I shudder to think of what my kids have gone through, but I don't. I just sit around and fucking plow through these documents and smoke cigarettes and really hate myself for not having done the right thing in the first place. But I mean, whoever knows what that is, certainly not I.
The deck is stacked against us. There's so much that is hidden. When you see your opposition coming from chambers with the judge, know that there's ex parte.
There you have an ex parte communication. So you hit that judge, you make a bar complaint against the judge and the attorney, and then a bar grievance. You grieve them both, and then you file a judicial complaint with your state's House of Judiciary Committee.
Of course, we've gotten each of the attorneys, the court appointeds as well as the private one that we contracted with, I guess, because
when you say got, what do you mean? How have you gotten them?
Well, we have filed those grievances like you were talking about earlier. And of course, only one because it came back nothing to see here. Fox.
Yeah, there is. That's how it's going to go. So here's what you do is you find 3 things, and trust me, you're going to have so many things before you get into the second section of the attorney's ethics document that your head's going to spin. So don't sweat whether or not they've done 3 things. They've absolutely done 3 things. I guarantee you're not going to get to the 3rd chapter of that list before you've got 3 things. I guarantee. So you just go through and you grieve them once every 30 days. And I think every state now, 3 bar grievances in a year, they lose their license for a year. And that's not their bar card, their bar membership. They'll keep that. They'll lose their business license. There is no law license. Let me be just very upfront with everybody that's watching this from here till the end of time. There is no license to practice law. There is no license to attorn, to esquire, to anything like that. These are false. They're as untrue as football bat. So just keep that in mind. And anybody standing accused or trying to be sanctioned for practicing law needs to raise the argument and question, am I practicing law? Where does it show me in your little book there that I can't study the law or that I can't help my fellow man? They have a right to counsel. They don't have a right to attorney. You know what I mean? Your right to counsel is protected, not your right to bar member. So I've got some laws of here and decisions from the Supreme Court on void orders. we can go through that if you'd like.
Yeah, and I also included all the relevant case law where parents are the ones who have exclusive right to the care and custody and control
So
of
then
children.
once this is all there, then you need to get your transcripts. And if you've set your record for appeal, then and objected to every single thing they've done. And
No, of course not. Nope. We were in the courtroom, threatened, intimidated. Do you want to go to jail?
they
Attorney.
can't put you in jail for a civil action.
Well,
And I mean,
don't think that he didn't use that at least a half a dozen times over.
right. Well, they're allowed to lie to us. They're absolutely allowed to lie to us as much as they'd like. This is some stuff that even prior to Obama passing that executive order where the media could use propaganda on us, they've been allowed to lie to us, I think, since the 70s or something, but they've probably been allowed to lie to us forever for all intents and purposes.
That's interesting.
So what I got here says that a judgment may not be rendered in violation of constitutional protections. The validity of a judgment may be affected by a failure to give the constitutionally required due process notice and an opportunity to be heard. This is Earl v. McVeigh, 91 U.S. 505-23L, edition 398. So it's also under restatements and judgments. That's a 4B, Prather v. Lloyd, 86 Idaho 45 382 P2D 910. The limitations inherent in the requirements of due process and equal protection of the law extend to judicial as well as political branches of the government. So that would be the executive branch, like it is. So that a judgment may not be rendered in violation of those constitutional limitations and guarantees. Now, this is just back on that thing that I've been trying to drive home to everybody. You don't have constitutional protections, and that document is not written for you. That Bill of Rights is loosely written for you, but it's more of a regulatory thing for them. Like, all of this stems from us. If we don't have the power to arrest somebody, how can we give deputized sheriffs the power to arrest somebody? If we don't have the power to overturn judges' rulings, how could we give judges the power to, administer these rulings? So I can't give you permission to go hang out at a dude's house that I don't know. And I can't give you permission to go back behind the counter at Walmart at the help desk. That's because I don't work there and I don't have that authority. So it's important to remember that these people are public servants. Public service is a public trust under the United States Code, and they're trustees. They're your trustee, to be specific. You're the boss. That's why you'll be the one asking questions. I don't fucking answer questions. I don't fucking answer questions for anybody unless I'm trying to help them. That's the only time that if it's not me intending to do a thing for you, for your benefit, then I'm not answering any fucking questions. I don't give a shit if it's where's the bathroom, like they're not asking me anything ever. You know what I mean? Unless I'm under some sort of arrest, custodial or otherwise, and being interrogated, I don't answer questions. Even when I'm being interrogated, I don't answer questions. Like, it is only Tuesday, but I guess we'll take a page from Shut the Fuck Up Friday and just remember that you don't have to answer these people's questions. They can't even present their fucking authority. And if you go back to the Abraxas live stream just a couple of days ago, last week, I think it was, you'll see in a very short time how this works with or without a stop. They can't present any kind of authority. So.
Yeah, that's the other thing. Challenging that's the quo warranto. That was numero uno. The first thing is, by what authority do you seize the keiki, traffic them over to another family, listen to conspiratorial parties who are in violation of their oath? And you just mentioned that they're supposed to provide us with notice of due process and constitutionally protected. And of course, no such was provided. We had to just go digging ourselves. Hey, number 2 was violated. We weren't allowed to record. Number 1 was violated. We weren't heard. We were suppressed. We were threatened.
Right. Correct.
So there's a live stream called the Abraxas live stream, and you mentioned Estopel. Can you explain that?
Okay, so estoppel is I got a train coming by. 1 sec. I'm gonna run a little thing real quick.
Okay.
And
Pretty much everywhere, it's gonna be hot. Try that.
And I don't need a jacket.
It's gonna be hot.
Thanks, Arthur.
Jingo biloba. Abba, abba, abba.
Listen, repealing Obamacare is not going to be easy. Passing a simple flat tax and abolishing the IRS is not going to be easy. But if we stand with the American people, we can do it.
Thank you for including me in the debate. Governor Bush, I want to.
Yes, yeah.
You have said illegal immigrants, quote, broke the law. What does that mean to you, and how does that inform your approach
feel like
to immigration reform?
Great question.
Jeb is a mess. Mess.
Jeb Bush is the weakest person on the stage by far. Jeb is a waste, and everybody knows it. He is so weak, it's laughable.
Jeb is a mess. Jeb is a waste. Jeb is a mess. Jeb is a big fat mistake.
I got to tell you, this is just crazy, huh? This is just nuts, okay? Jeez, oh man. Jeez, oh man. You know, this is the standard operating procedure to disparage me. That's fine. I don't
No, excuse me, Jeb. Jeb is a big fat mess.
Okay, Governor Bush, I think
I got to respond to this. The reason why I should be president is, great question. The reason why I should be president, I feel like I have to,
Excuse me. 2 days ago, he said he would take his pants off and moon everybody. Nasty guy. He's a nasty guy. Jeb is a nasty guy. I want to tell you, I don't often agree with Marco, and I don't often agree with Ted, but I get along with everybody. I say this every night, every day, every afternoon, and it's so true. Jeb is a mess. Jeb is a waste. Jeb is a big fat mess.
Okay, yeah, I'm having some technical difficulties again with the platform, and that is because Gage and StreamYard are both extremely non-hetero. Right, so where were we? We were talking about estoppel?
Yes.
Okay, so estoppel is the process or method by which somebody is impeached, I guess, sort of, so to speak, from the legal process. If you're in estoppel by any number of ways, then you can no longer present any kind of evidence or testimony, and everything that you've have done so far within the scope of suit or action, whatever the action is styled in, is considered to be in question. You know what I mean? So you can have things quashed or stricken or removed. You know, just depending on what it is. It's estoppel is a whole episode in and of itself. That's just one of the many ways that you can handle a defect in something. So void judgment is not entitled to respect according to valid adjudications, but may be entirely disregarded or declared inoperative by any tribunal in which effect is sought to be given to it. It is attended by none of the consequences of a valid adjudication. It has no legal or binding force or efficacy for any purpose or at any place. It is not entitled to enforcement. All proceedings founded on the void judgment are themselves regarded as invalid. This is a 30A, American Jurisprudence Judgments, and that's 11th edition, page 44 and 45. It's a fundamental doctrine of law that a party to be affected by, to be affected by personal judgment must have his day in court and an opportunity to be heard. This is Renaud versus Abbott. It's a landmark case. Every person is entitled to an opportunity to be heard in court, in a court of law, upon every question involving his rights or interests before he is affected by any judicial decision on the question. This is Earl versus McVeigh. So no opportunity to be heard, it sounds like, is what you're dealing with. A judgment on a court without hearing the party or giving him an opportunity to be heard is not a judicial determination of his rights. And this is Sabaregio versus Maverick, and that's 124 U.S. 261 31 L edition 438 SCT 461, and is not entitled to respect in any other tribunal. A void judgment does not create any binding obligations. Where'd it go? Sorry about that. Does not create any binding obligation. Federal decisions addressing void state court judgments include Kalb versus Fauerstein and Ex parte Rowland. So that's an 1882 case. The older the better, I find, especially for source material concerning religion or anything like that. A judgment which is void upon its face and which requires only an inspection of the judgment roll to demonstrate its wants of vitalities is a dead limb upon the judicial tree, which should be lopped off if the power to do so exists. That's the People versus Green, 71 California 100, 16 PAC 197, 5 AM 448. If the court grants relief, which under the circumstances it hasn't any authority to grant, its judgment is to that extent void. And that's Freeman on judgments. An illegal order is void forever. Facts. You got any questions?
I'm just going to have to go back and listen to it slowly.
Preguntas.
No preguntas. Just
okay.
Write it down.
So you can go back and read any or listen to any of this any number of times. I got like dead air and slow moving through stuff is it doesn't really work for me too much. An order that exceeds so this is orders exceeding jurisdiction. An order that exceeds the jurisdiction of the court is void and can be attacked in any proceeding in any court where the validity of the judgment comes into issue. Rose versus Heimlich, Penoyer versus Neff, Thompson versus Whitman, Windsor versus McVeigh, and McDonald versus Maybe. If a court grants relief, which under the circumstances it hasn't the authority to, we just that Freeman on judgments. A court must vacate any judgment entered in excess of its jurisdiction. This is Ubin v. Selective Services Systems Local. A void judgment does not create any binding obligation. Federal, wait. Okay, yeah, we've already read that too. Mm-hmm. So void orders can be attacked at any time, and they can. They can be attacked at any time in any venue, essentially, give or take. An order that exceeds the jurisdiction of the court is void or voidable and can be attacked in any proceeding in any court where the validity of the judgment comes into issue. That's Rose versus Henley again. Portions of the judgment directing defendant not to import vehicles without first obtaining approval was not vacating it as being prospectively inequitable. This is going to be U.S. versus Holtzman. So yeah, no, there's a lot of things that we do here to kind of streamline the process of getting these judgments overturned. And that's all stuff that anybody can feel free to reach out to me on at any point in time. My number is not hard to find, but in case somebody doesn't have it, it's 316-207-2041, or I can be reached at the foundation at 316-932-4247. That's the Fountain and Associates Charitable Trust Foundation. Any donations, and all donations there are 100% tax deductible. You're able to give up to 30% of your income, and because it's my charity, I can do whatever the fuck I want with it. So we could discuss how that could be given back to your community. So anyways, enough with the hints there. That's a 508c1a. If anybody wants to look into that, hit me up. bleaknarratives@gmail.com. Next, we would have it's going to be 18 USC chapter 505. This is in regards to seals again. Let me see if I can get this drawn up here. It's giving me some grief.
I heard it has to be in the upper right-hand corner of the front page and on the reverse side of the final page.
Right.
Because otherwise
here we go.
they could just insert.
Okay, so I think we already did 18 USC 505, so we're going to move into 28 USC chapter 113. And this is going to be process and test date, I think. The seal and test of the process. Let's see. So this is all writs and processes issuing from a court of the United States shall be under the seal of the court and signed by the clerk thereof. Now, it's imperative that we understand the definition of signed. So let's go ahead and get that. This is where my mentor was amazing. Jason was one to read the definition of thing, man. He'll have people trying to just do somersaults to jump into their own ass. A legal signature is a mark or name that a person makes on a document to show that they agree to the conditions of the document and that they're legally authorized to do so. A signature can be handwritten, electronic, or a digital code. Now, do you see stamped on there?
Nope.
It does not say lithographed. Identifies a signer. A signature shows who is performing the act of signing. It shows intent. Signature shows that the signer intends to endorse or authenticate the document. This means that there will be performance. If somebody's going to sign something, that means that they'll swear to the veracity of it. It means that they'll attest to it in a court of law. Meets legal requirements. A signature must adhere to any legal requirements outlined in the document or relevant law. So a signed contract is a legally binding agreement. A signed contract shows that the signer was competent to enter into the agreement and did so willingly. Other types of signatures are a facsimile, a signature that has been reproduced mechanically or photographically. Now, mechanically would be you hand over fist stamping. So this would be a facsimile. So we could check on the legality of facsimiles in legal documents, but I don't think that's entirely necessary. We can safely assume that what they're doing in these courts, just based on the clerks themselves, is not legal. Then the judicial determinations that they're giving us are garbage. The due process and the right to be heard is being just completely trounced by these people. It's,
Yep.
I don't know. It's gotten out of control. It's gotten out of control. I know that much. So I've got this document called 22 Reasons to Vacate a Void Judgment. I'm going to let the computer roll through this real quick. If you feel like dropping out at any point in time because you're tired or you have things you need to do, you're welcome to. But just for the sake of having this on the record here, and so that people can check it and validate the stuff themselves, I'm going to go ahead and run this while we're on this episode. So
I'm going to bounce you an email so that you can send it to me if you wouldn't mind, please.
Easily found on my Telegram, and so I would encourage anybody to go ahead and check out the group on Telegram. It's very small. It's not private, but if that makes any sense. All of the people there are people that you can reach out to. They'll help you. The bots that I have on there are amazing and very helpful. It's like everything else that I have. I water it every day and it doesn't fucking grow. So cheers to that. All right. So without further ado, I'm going to go ahead and turn it loose to text to speech. T2S is an amazing program. It's an app that's available either by APK on Up to Down, or you can get it on the Play Store as well. So cheers. And if I don't see you before or hear from you before the end of this, I'll holler at me a little bit later and we'll get after it. Sounds like there's another train coming by, so hooray.
Constantly.
Do you have a jurisdictional argument you want to make?
Well, I served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Yep. Nothing really. Yeah, I don't know what any of this stuff is.
Don't do it! Just don't do it! Let your dreams be dreams. Yesterday, you said tomorrow. So just don't do it! Don't make your dreams come true! Just don't do it! Some people dream success, while you're gonna wake up and let your dreams be dreams. Nothing is possible! You should get to the point where anyone else should do it, and you're gonna stop there! No, what are you waiting for? Just don't do it! Yes, you can! Let your dreams be dreams. Just don't do it! Don't do it! If you're tired of starting, just give up. Just give up.
I need you to be honest with me. Oh, I am being honest with you, dude. This is gonna go a lot easier if you're honest. And I will, yeah, dude. Yeah. What are you on right now? Cloud9 with On Cloud 9?
No, what are you on right now? You
One?
gotta be honest.
I'm on one, dude. You know what I'm saying?
Stop fucking around. What are you on right now, man?
TikTok, what? Instagram, all of it. I'm on all of it.
I'm not talking about your ass. Drugs.
Oh, sure, if you got some. Yeah, I'm down. You got a party? You know.
Step out of the car.
Okay, so I'll be sure to text you a link after this is over and it's published to YouTube. It's live right now, so you can find it on the channel, which is I think it's just the bleak narratives. I'm not really sure.
Subject
Thank
matter
you.
jurisdiction. Void judgments are those rendered by a court which lack jurisdiction, either of the subject matter or the parties. Wall versus Round Valley Bank 38 Aries 411 300p 9 305 146 P203 1914 US 385 Ed 2D278 1940. I can go into void body's eyes glaze over, but I shall refrain. Let it be said that mutual consent of the parties. Subject matter jurisdiction is two-part. The statutory or common law authority for the court to hear the case and the appearance and testimony of a competent fact witness, in other words, sufficiency of pleadings. Even if a court judge has or appears to have subject matter jurisdiction can be lost. Major reasons why subject matter jurisdiction is lost. No petition in the record of the case, Brown v. Van Kuren, 340 ill. 118,000. 3 fraud committed in the procurement of jurisdiction, Fredman Brothers Furniture versus Department of Revenue, 109 ill. 2D 202, 486 NE 2D 893, 19 Ray Village of Willowbrook, 37 ill, app. 3D 393, 1962. 5. A judge does not follow statutory procedure, Armstrong versus Obuchino, 300 ill 104, 1921. 6. Unlawful activity of a judge, Code of Judicial Conduct. 22 reasons a judgment is void. The really big deal is subject matter your web links. 1 of 5 the 4th of October 2013 12:15 versus Zerbst 304 US 458 58S Court 1019 City of Northlake 10 ill 2D 241 245 140 NE 2D versus Goldblatt Bros 363 ill 25 1936. 8. If the court exceeded its statutory authority. Rosensteel v. Rosensteel, 278F. Sup. 794 SDNY. 1967. 9. Any acts in violation of 11 USC 362 A in Ray Garcia, 109 BR. 335 N. D greater than Illinois, 1989. 10. Where no justiciable issue is presented to the court through proper pleadings. Ligon versus Williams, 264 ill. App 3D 701, 637 NE2D 633 First Dist. 1994. 11. Where a complaint states no cognizable cause of action against that party. Charles versus Gore, 248 ill. App 3D 441, 618 NE2D 554 1 Street. Dist. 1993. 12. Where any litigant was represented before a court by a person, law firm that is prohibited by law to practice law in that jurisdiction. 13. When the judge is involved in a scheme of bribery, the Alaman cases, Bracey versus Warden, U.S. Supreme Court No. 966133, June 9, 1997. 14. Where a summons was not properly issued. 15. Where service of process was not made pursuant to statute and Supreme Court rules, John O. v. Bacon, 6 ill. 2D 245, 249, 218 NE2D 706, 708 1953. 16. When the rules of the circuit court are not complied with. 17. When the local rules of the special court are not complied with. 1. Where the judge does not act impartially, Bracey versus Warden, U.S. Supreme Court No. 966133, June 9, 1997. 18. Where the statute is vague, People versus Williams, 638 NE2D 207 First Dist. 1994. 19. When proper notice is not given to all parties by the movement, Wilson versus Moore, 13 ill. App. 3D 632, 301 NE2D 39 First Dist. 1973. 20. Where an order judgment is based on a void order judgment, Austin versus Smith, 312 F2D 337, 343, 1962. English versus English, 72 ill. App. 3D 736, 393 NE2D 18 First Dist. 1979, or 21. Where the public policy of the state of Illinois is violated, Martin Tregona v. Roderick, 29 ill. App. 3D 553, 331 NE2D 100 First Dist. 1975. 22 reasons a judgment is void. The really big deal is subject matter. Webworth of October 2013, 12:15 a.m. and another that can and should be checked on is, does the judge have a copy of his oath of office on file in his chambers? If not, he is not a judge, and yes, you can go into his office and demand to see a copy of his oath of office at any time. The laws covering judges and other public officials are to be found at 5 U.S.C. 3331, 28 U.S.C. 543 and 42 U.S.C. 1983, and if the judge has not complied with all of those provisions, he is not a judge but a trespasser. If he is proven a trespasser upon the court, upon the law, not one of his judgments, pronouncements or orders are valid. All are null and void. In all, there are 22 indices which tell us whether or not a court had subject matter jurisdiction, and when examining a judgment one has to know each and every one of them by heart. If he knows them by heart, he can go through a judgment like Sherman going through Georgia and point out all of the errors which might make the case a void judgment, null and void upon its face. Summary of the law of voids. Before a court judge can proceed judicially, jurisdiction must be complete, consisting of two opposing parties, not their attorneys. Although attorneys can enter an appearance on behalf of a party, only the parties can testify, and until the plaintiff testifies, the court has no basis upon which to rule judicially, and the two halves of subject matter jurisdiction equals the statute indemnity and the testimony of a competent fact witness regarding the injury, the cause of action. If there is a jurisdictional failing appearing on the face of the record, the matter is void, subject to vacation with damages, and can never be time barred. A question which naturally occurs: if I vacate a void judgment, can they just come back and try the filed? And that can only be done if within the statute of limitations. Lack of jurisdiction cannot be corrected by an order nunc pro tunc. The only proper office of a nunc pro tunc order is to correct a mistake in the record. records. It cannot be used to rewrite history. E.g., Transamerica 325 to 26 7th CIR. 1992. United States versus Daniels, 902F. 2D 1238, 1240 7th CIR. 1990. King versus Ionization International, Inc. 825F. 88 7th CIR. 1987. And Central Laborers Pension and Annuity Funds versus Griffey, 198F. 3D 642, 644, 7th CIR. 1999. No practical way to estimate how many there are. If every void judgment was vacated with damages, it would represent the greatest shift in material wealth in the history of the world. 22 reasons a judgment is void. The really big deal is subject matter error. Web links. 3 of 5, the 4th of October 2013, 12:15 a.m. Void judgment details. 22 reasons simply stated. Restated with evidence cited. Meet Richard Cornforth. Sue debt collectors instead. Support docs for suing debt collectors.
All right. So that was obviously a Richard Cornforth document. It's pretty good stuff. You can find a lot of really good. Let's see what we've got in here for court seals. Sorry, I just got to dig around in here because I'm not very good at organizing. And so.
If you remember the title, you're it's half the battle.
Right. Right. So I don't know. I guess we've had a couple people watching. There's nothing in the comments. It doesn't look like anybody's got any questions. I might go ahead and cut this here before too long.
Yeah. Throw that.
So chat real quick, and if anybody wants to come in, and we'll go.
Throw that chick's name for the seals. She had a British accent.
Pardon?
The woman who you said to go listen to her materials about the seals.
All right. Well, I seem to have lost you there. I didn't catch that.
Seals. Remember the lady who is the authority on seals? Throw her name in the chat too.
Yeah, about the seals.
Mm-hmm.
There's a bunch of Jackie Fig stuff that's already been posted. You know what I mean? Online here on YouTube and other places. I would recommend that anybody just looking at Jackie Fig's research there. If I really need to go into the seals and stuff, I guess I can. But that's one of those things where due diligence is a big deal. You know what I mean? And so like you gotta be willing to look for this stuff yourself. You know, to some extent.
Yeah.
And that's kind of the problem I'm having on the home front. I guess I'm about to relocate halfway across the country to solve problems for somebody that doesn't want to fucking do any of her own work. And this is primarily the type of people that I work around and work with and for, I suppose, as I myself am somebody that's largely abrasive and tough to deal with. I understand. I get it. Nobody wants to work with your ass. And so bring it on over here and we'll get something figured out, that's I got to take the ones that nobody else wants. Otherwise they won't get taken,
Oh.
But let's see where we are here. Doesn't look like I've got too many documents on the seals. Go back into the onto the old interwebs and see what we got on here. So,
Thank you. I'm in the chat.
Here we got a 32 CFR 150.1. It's a name and seal. The titles of the courts of criminal appeals and the respective services are the United States Army Court, the United States Navy, Navy, blah, blah, blah. Each court is authorized, blah, blah, blah. Okay, so that's all for military tribunal stuff. Let's see what we got here. Official seals. This is going to be Code of Federal Regulation. It's going to be Title 36, Chapter 12, Subchapter A, Part 12,000 or 1200. Official seals. Let me get this going right here, and we will run it through the old bot. All right, stand by.
Standing by.
The following definitions apply to this part. Embossed made on a die so that the seal can be embossed on paper or other medium. NARA means all organizational units of the National Archives and Records Administration. NARA logo means programs, products, or services. Official seal means the originals of the seal showing the exact form, logo displaying the form and content. 67 FR 72101 Deck 4 46 May 11th 2004. Subpart B. How are NARA's official seals and logos designed and used? Is each NARA seal designed? NARA 83 official seals are illustrated description of each seal. The design is illustrated below in Figure 1 and described as follows. 1. The seal is centered on a disc with a double records administration. Circle the inside of the seal and the date 1985 is at the bottom center. 3. A solid line rendition of a hurrah in its right talon a branch of olive, bearing on its breast a representation of the shield of the United States. 4. The other. Web links.
Okay, and the following is going to be 19 CFR, so to be seals as well. So this was the record archive that we just heard. There's a principal and surety. If individuals and the corporate seal must be affixed, that's telling right there. The corporate seal must be affixed close to the signatures of the person signing on behalf of the corporation. That's pretty telling there. Bonds must be under seal in accordance with the laws of the state in which it's executed. However, when the charter or governing statute of a corporation requires its acts to be evident. Now, there are accidentally choose words to use. They do not. I repeat, do not do that. This is something that is entirely done on purpose. These people will filibust for 6 hours to make sure that somebody doesn't get a chance to get something passed. Way that they don't mean to say corporation. So, see what this judicial canon court order is that I pulled up.
Did it say that bond has to be indicated under the seal?
Yeah. Did it say what?
that their bond, their indemnity bond, has to be
Oh, Custody, I got
present.
another train coming by. You're gonna have to speak a little louder.
The indemnity bond has to appear. Hello?
I've got a train coming by, so it's going to be loud as shit. I live right next to the tracks. If it did say something about and it did say something about the bonds, I've already closed the window, but you can go back and somewhere in the you're just gonna have to go back and watch it.
Yeah.
But messages and hold on. Let me see. Okay. Yeah. Okay. All right. Here we go. So the next one is going to be, let's see. So this one's going to be a document off script. It's a motion to quash somebody making a special appearance. I'm not going to read all of that crap. It's a notice of motion to quash simulate script yourself or reach out to me and I'll send it to you. So please take notice that the above reference hearing date at the above reference hearing time or as soon thereafter as the matter may be heard, defendant such and such will appear specially and move the court for an order to quash the plaintiff's void process, namely the summons. The motion is made pursuant to Code of Civil Procedure 412.20 and 1167 on the grounds that the named recognize the simulated legal process as a summons for the reason by CCP procedure, but you'll have your state's equivalent. It's been enumerated into positive law, I'm sure. Subsection 412.20. Therefore, the purported such or other oral and or documentary evidence as must be. Well, you must also provide your points of authority and a memorandum at law, and you have to also provide them with an order for them to stamp, or they will not do it. You know what I mean? It's just not going to happen. So, this may be why you didn't really get heard in your court, because if you're appearing pro se or you're not making a special appearance in your belly or whatever, they're not going to hear it. And this is just how it's set up. It sucks, but I mean, it's the world we live in, and it's what we got to deal with currently.
I completely missed the point, the last point that you made, because I guess it was buffering or something.
Okay. So I'm not really sure. These things they come right through me or Taco Bell, so I can't say for certain what it is I said. You'll have to go back. But apparently it didn't register, and I need a little daddy time, and it's just not happening. So it says memorandum of points of authorities. God man, of course, date of this writing, it says that the named defendant denies being served a valid summons and complaint. Named defendant does not. I think that's it. So legal argument. The case law is clear. So this is stare decisis. It's been decided that once the defendant has filed a motion to quash the service for plaintiff, has the burden of proof. Once the defendant files a motion to quash, on the burden is on the plaintiff to prove that the by preponderance of the evidence, which is anything better than a 51% consent. This is going to be Balkaya versus Superior 9th, maybe district. A defendant, no, it's not the 9th. I don't know. So it's the 4th in the appellate courts of California. Liberty and made satisfaction of the court. That's Taylor Rush v. Multitech Corp.
Hey, Kevin.
Authorities are uniform that is void.
Kevin.
If issued without a seal, and that's Aetna Insurance Company.
Hello?
Here we go. So, sorry about that.
We should probably.
The next thing would be out.
It's unintelligible from my perspective. We should probably just go ahead and call it a night. I haven't caught anything for the last maybe 5 minutes.
Okay. Yeah, sure. You can go ahead and drop out. I'm going to go ahead and try and read this. If it doesn't work, it doesn't work. There's 2 people on here, and I'm assuming that they can hear it, or they would be in the chat saying that they can't. But
Okay.
It's very glitchy and crappy on my end as well. But yeah, you can go ahead and drop out. I'll try and do the rest of this, and I'll send you a link as soon as it's finished.
Thank you. Don't hesitate to bounce anything that you were reading over to the email too, so that I can actually take advantage of what you shared.
Sure. I'll have to just go back through and see what all I've accessed tonight, and I'll try and send it to you.
Okay. I look forward to speaking with you again.
All right.
Thank you for your time.
Oh, yes, ma'am. Cheers.
Cheers. Good night.
Uh-huh. Cheers. All right. So where were we? We were here. We were right here. Where am I? I am also here doing this now. Shit. Yeah, man, it's so hard for me to stay focused. I need better drugs. Okay, so the next point of authority that this guy's using in his memorandum is that the paper title summons served is void. It says the Code of Civil Procedure states that a defendant may file a motion to quash service of summons on the grounds that the lack of jurisdiction of the court is over him or her. So the main grounds used are that the service on the defendant was defective and the court does not acquire jurisdiction on a defendant unless proper service of summons and complaint has been made. This is so even though a defendant may be a resident of California or whatever. So the California Civil Procedure, it says that, here we go. California Code of Civil Procedure, subsection 412.20 expressly deals with the jurisdiction of the court and the requirement that a summons shall be directed to the defendant, signed by the clerk, and issued under the seal of the court in which the action is pending. In this instant action, the summons directed to the defendant contains no court seal. This is despite the fact that it is said from the title, summons provides a designated space for the court seal to be affixed, and it cites the same code as above, the CCP 412.20. So additionally, the burden to obtain the correct number of copies of valid summons to be directed to the defendant lies with the plaintiff. Getting a bunch of text, sorry. That would figure. After payment of all applicable fees, the plaintiff may have the clerk issue one or more summons for any defendant. The defendant does not waive plaintiff's duty to obtain a copy of a valid summons. Furthermore, even in the case of the electronically filed summons and complaint, a trial court, upon request of the party filing the action, shall issue a summons with the court seal and the case number. The court shall keep the summons in its records, and may electronically transmit a copy of the summons requesting to a requesting party. Personal service of a printed form of the electronic summons shall have the same legal effect and force as personal service of the original summons, according to California's government code. And this is going to be subsection 68074.1. The seal of any superior court may be affixed by a seal, press, or stamp, which will print or emboss a seal, which will reproduce legibility under photographic methods. So it has to be raised. It has to be an embossed and raised seal, like I was saying. And this is going to be in every state. It'll be enumerated into your state's or annotated into your state's code. Sorry, not enumerated. It stands to reason that if the seal required to produce legibility under the photographic methods, that if the seal is required to reproduce legibility under photographic methods, then the defendant is entitled to have a copy of the original summons that is directed to underscored, signed by the clerk and issued under the seal of the court in which the action is pending. In fact, the only exception to this would be if the summons was transmitted by telegraph, and this is going to be under California Civil Procedure, subsection 1017, where the exception is expressly provided. The defendant believes that this instant matter and said summons was not transmitted by telegraph, and therefore blah, 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 blah. Motion to quash service is a special appearance, meaning that it does not admit the court's jurisdiction over the defendant. The case law in California is well settled that a defendant files a motion to quash the service of the plaintiff has the burden of proof, proving that the summons is valid. Once the defendant files a motion to quash, the burden is on the plaintiff to prove by preponderance of the evidence that the validity of the service on the court's jurisdiction over the defendant exists. The court in the states of California have ruled that a defendant is under no duty to respond to a defectively served summons until the plaintiff shows the service is valid. I'm going to go ahead and run another one of these. And trains. Tell you what.
That's why the Nazis were studying mind control. What the Nazis had settled on for mind control was that the person first needed to be malnourished. The second thing was they needed to have heavy metals. Aluminum was their one of choice at that time, deposited into their bodies. The third thing that they needed was to have negative stimulus, punishment if you don't do what we tell you to do. And then the fourth thing, repeat messaging. When you do those four things, what you create is a person who is now willing to suggestibility and willing to be controlled in their mind. In 1945, Allen Dulles brings 1,600 Nazi scientists into the United States. Paperclip. He clears all their records, makes sure they avoid getting involved in the Nuremberg trials. All of them certainly would have been sentenced to death. He brought them into the United States, put them in our government, and gave them unlimited funding because he loved what they were doing with mind control. These scientists brought all the Nazi science into the United States. And so now you have rollout of the Nazi agenda in the United States and then starting to go globally because everybody is taking what the United States is doing as the way of the future. Those repeated messages that the Nazis were doing, those became commercials.
All right, all right, all right.
If you really want to be transformed, you have to live an intentional life. This is so simple, I don't want you to miss it. Most people don't lead their life, they accept their life. And when you accept your life, you are living on things that are not worthy of your time and effort and energy. To go uphill, you have to be intentional. Nobody ever went uphill by accident. You've never read a book on accidental achievements. You have to be intentional with what you do and who you are.
Yep. This is true story, and truer words have probably never been spoken, ladies and gentlemen. I am and have been for this evening the one and only Bleak Narratives, Kevin Michael Talbert, at your service. And tomorrow I will be history. As always, go your good way, brothers and sisters. Cheers.